Hi, good afternoon, and welcome to ENS Africa's webinar this afternoon around POPIA and IP. Thank you everyone for making time in your very busy diaries to join us for the session. I'm sure many of you are scrambling with your POPI compliance, and we know that we're just a few short weeks away from the elusive 1 July deadline. So today I am joined by a panel of esteemed colleagues, Ira Gunning. Ira is an executive in our banking and finance department and part of the data privacy team at ENS Africa. She advises clients on POPIA, consumer protection, and all other sorts of regulatory matters. I'm also joined by Nicole Gabre. She is an executive in our dispute resolution department. She specializes in data protection, cyber risk matters, data breach and incident response management, commercial litigation and insurance claims. Last but not least, I'm also joined by Andre Murray. He's an executive in our intellectual property department. He specializes in commercial and transactional intellectual property matters with a specific focus on IP, aspects of the pharmaceutical industry, commercialization of IP assets, patents, domain name management and enforcement, and IP licensing strategies. And my name is Raki Dilib. I'm an executive in the technology, media, and telecommunication team in the corporate and commercial department, and also specialize in data privacy law. I'll be facilitating today's conversation, and I hope you all enjoy it. Please do feel free to drop a question in the Q&A section, and we'll try and address them towards the end of the session. Okay, for many of you who may not know, I'll just give you a quick crash course in POPI and POPIA, if you like to call it that. We all are trying very hard to use the word POPIA as the information regulator has indicated our preference, but all habits die hard, so you'll hear us say POPI every now and again. So what is POPI? POPI is the Protection of Personal Information Act. It was promulgated in 2013 and it was hanging around for a very long time until in the midst of the COVID pandemic, a commencement date was announced. And from 1 July of last year, we've been in this grace period of 12 months where everyone is losing their mind trying to become compliant with POPI. So that's kind of where we are at the moment. And I think it's essential to know the basic definitions of POPI or POPIA, the first of which is, what is personal information? Now, personal information is any information that is able to identify a person, and under POPIA, a person relates to either a juristic person or a natural person, such as you and I. So interesting fact, POPIA, or South Africa's data privacy law, is one of the only laws in the world, to our knowledge, that deals with personal information of juristic entities, which has made the compliance journey that much more complex. But in any event, POPIA does go into listing all kinds of categories of information which would be considered personal information. These range from things like, your name and your surname, your address, your gender, your race, your ethnicity, your employment history, your biometric information, correspondence, which might be of a private nature, and all sorts of other, fun categories that I'm sure we'll pick on a little bit in the discussion this afternoon. We also have special categories of personal information called special personal information. And these are categories which are considered more sensitive. And, there are additional requirements that are placed on responsible parties when they process special personal information. And then lastly, we have the definition of process. And I just like to say that process can mean anything. Anything that you can possibly try and do with data will constitute processing. And insofar as you process personal information in South Africa, if you're domiciled in South Africa, and you intend for that, processing to form part of a record, then, you will be caught by POPIA. So there are very few instances when POPIA won't actually apply to you as an organization. And that's why, it does affect almost all organizations in South Africa. Just to quickly mention a few of the role players, many of you would already know we have the Information Regulator of South Africa. They are the body that's tasked with ensuring compliance with POPIA by all organizations in South Africa. They also will deal and handle any complaints and respond to data subjects that would like any investigations to be done in terms of the processing that organizations are doing. We have obviously data subjects, and data subjects are those persons about whom personal information relates. And so, they could be you and I or any company, depending on the context. So it's customers and suppliers and employees. And then you also have a responsible party. Now, the responsible party is the person who determines the means and the purpose of the processing of the personal information. And an operator is a third party who would be sort of contracted to process personal information on behalf of a responsible party. So that should just give you a very high level overview and set the scene for some of the words that we may use in the presentation. If you're not familiar with the terminology, that should sort of just, help you in here. So being the POPI nerds that we all are on the call today, we're always fascinated by the intersection of, the various laws, sectors, and industries, and what, compliance with POPIA means in respect of each of them. And so that's why we thought it would be really interesting to have a bit of a discussion around, what are the intellectual property considerations when you're looking at data privacy law as well. So the first thing that I thought would be quite interesting to understand, and perhaps, Andre, if you'd like to come in here, what are the categories of intellectual property that would constitute personal information?
Thanks, Rocky, and hello, everyone. Just as an introductory comment from my side, I'd just like to say that I am not a POPI nerd. I'm an IP nerd, so we look at it exactly the same, but just from the other angle. So it is quite interesting to see where data and data protection intersects with IP law, and we're finding it more and more in the transactions that we work on, where that's one of the underlying assets. So I think we have found that we've worked more and more with the POPI team as time goes on, which sort of prompted a lot of these discussions. So to answer the question of what categories of IP are involved in personal data, you actually need to take a few steps back and first try to identify which IP laws or which IP aspects are involved in sort of the two main categories there, one of which is data and one of which is databases. And that's quite an important distinction to make. The reason I say that is because the intellectual property rights in databases is quite a settled field of law. It does differ quite a lot from country to country, and it's had a long and sort of windy past, but there's a lot of certainty that there does exist intellectual property rights in the database itself. So what I'm talking about there is the consolidation of data points or individual data elements. I'll deal with the data elements just now. So when we're looking at the database, you are usually looking at copyright as the main form of intellectual property right involved there. But as I mentioned, it does depend on jurisdiction to jurisdiction what exactly the intellectual property rights would be that is involved. To give an example, Europe, for instance, has taken a bit of a different view from the rest of the world. And they've actually created a sui generis type right, which is a special type of right called the database right. And that right, it's sort of closely related to copyright, but it's a right that only really exists in Europe, and it only protects databases. Again, it doesn't protect the individual data points, just the database, the consolidation of the information. And that's quite an important element, because if you identify which type of right is involved, that usually drives what you can do with it and what the formalities are around treating that asset. I won't go into a lot of detail on this because it can get quite technical, but just as an example, if you've identified that copyright is the correct intellectual property right involved, then there are certain formalities around the assignment or the transfer of that asset, and certain formalities and rights on the licensing of that asset. And that can become quite important when you're trying to commoditize or trying to monetize these assets. So databases, relatively easy to answer. Data points themselves becomes very murky very quickly. And just to sort of tell you where I am in my thinking, I have the database, and then I've got the individual data points, and then under the individual data points would be personal information. So that can be a subcategory of an individual data point. So I'll first deal with general data points. There's case law in South Africa and in other places, which basically states that a data point by itself is not an intellectual property right. It's a piece of information, and it's generally open to use by everyone. There's, of course, always a backdoor to that, and it's not by any stretch of the imagination impossible for an individual data point to have intellectual property rights in it as well. I think the easiest example would be if your database comprises of a number of photographs, for instance, each one of the individual photographs can have copyright in that. So that's different from, a telephone number or a how many cars stopped at the robot type of data point. So the answer on that part is there can be intellectual property rights. Usually there isn't. If we drop that down one level, and this is where it becomes very murky, is whether there is intellectual property rights in personal information, and if there is, who owns it. And that can be a crazy academic meander, which I went on in the last week while preparing for this, and I don't suggest that anyone do that. The short version is it's unlikely that there can be intellectual property rights in those personal information sort of data points. But there's a lot of movement around the world, and it started about 10 or 15 years ago, and it just sort of resurfaced again in the last 2 or 3 years, where there's a big push, especially in the US, to try and shoehorn personal data into some form of a intellectual property right or an intangible right. And the thinking is that a lot of the people who support this view feel very strongly that individuals should be able to take advantage of the value in that, call it a property right if you want to, an intangible property right. And just some of the examples, there was a bill that made it to the floor in the US, I think in 2019, that specifically pushed to say, you've got property rights in these things, and these big social media companies need to pay you to use that information. And the other interesting development there was an artist, which I'm very proud to say I know who it was. will.i.am wrote quite an interesting thought piece on whether that constitutes a property right and whether you have rights to the type of money that the social media industry makes from that data point. And they raise a few very good points. I'm not convinced that it fits in with the normal intellectual property rights. And I'll talk about that in a little bit more detail later. And we're probably looking at something like a personality right, where it's more an intangible right, and your value derives from how you monetize that rather than the right itself. I don't know if that makes sense. Ira, have you got any comments on that?
Yeah, absolutely, Andre. So this is the intersection between IP and personal information is obviously interesting. And if there's a conflict between the IP laws and POPI, then POPI says generally the law that gives the greatest protection to the processing conditions would prevail. So it'd be quite interesting to see how this pans out. But I just want to bring up the definition of personal information here. So personal information, as Raki has pointed out, is information relating to an identifiable person. And POPI is based on the EU directive, and I'm sure many of you know that. And most of the data protection laws throughout the world are based on the EU directive. Now, most of these laws, in fact, 50 laws that we've looked at roughly, only recognize human beings. But now, of course, as an identifiable person, we recognize existing juristic persons as well. So in the South African context, personal information would not only be something that relates to a human being, such as a photo of a human being, or education of a human being, or an email address of a human being. It would also be information relating to an existing juristic person. And I've always baffled with this. So a symbol of a juristic person is seen to be personal information. Now, generally, when I don't know what to do with something in terms of POPI, I go and see what has been said overseas, because POPI says we must take international standards into consideration. So we typically look at the GDPR and the Canadian Privacy Act and so on. But as far as a symbol, of a company is concerned, we don't know where to go with that. We don't know what it's going to mean. What does it mean when a symbol of a company is now personal information? So if I want to process, for example, a trademark of another company, then I now have to comply with the 8 processing conditions. So I'm just wondering, Andrea, have you given any thought to that? What do you make of the fact that we recognize a symbol of a juristic person as personal information, or nothing at all? Are we just reading too much into this?
I honestly don't know. We've looked at it in quite a bit of detail to try and figure out what exactly that means and what the practical implications would be of that element. You're quite right. I think in your almost in the academic version of the interpretation, I think a symbol of a juristic person or a natural person will certainly be a trademark or a logo. But then the reverse of that would be that's already public information. That's part of the public record in the trademark office. And the whole point of having a trademark in the first place is to sort of get it out into the public domain. Otherwise, it doesn't really serve its purpose. So I guess there may be some theoretical positions where you are consolidating a bunch of logos from juristic persons or whatever the case is, where some of those things would apply. But I actually don't exactly know what the repercussions, practically speaking, would be if you do something like that. I mean, if someone doesn't comply to those 8 things, what typically would be the recourse of the person who owns that logo? And perhaps,
Well, it's very difficult. I haven't found the answer in the last decade and trying to find the answer. But often we are told that, yes, it's in the public domain or information has been made public, so POPI doesn't apply. And that's actually not correct. So if you just do a search on public in terms of POPI, then you will see POPI does apply to information that has been made public or information that is available in a public register. But there's a bit of lenience in terms of the Act for using it. For example, in section 12, it says usually you must collect personal information from the data subject itself, unless, for example, it has been made public. Another example would be when it comes to processing of special personal information or information of children. And I'm sure everybody on the session today has had issues with special personal information and information of children. If that information has been made deliberately public by either the data subject, or in the case of a child, by the data subject with the parent's consent, then we can process that information. So there's a little bit of lenience in terms of POPI, but something being available in the public domain doesn't take it outside of POPI. So still, Andrea, I can't give you answers here. All I can say is if you are processing a symbol of a human being or a juristic person in terms of POPI, you're now going to have to comply with the 8 processing conditions. For example, you must have a lawful reason for processing that information. You must only keep it for as long as you've got that for a lawful reason. Any further processing must be compatible with the reason for collection. You need to keep it safe and secure. You must comply with data subject access requests and so on. But still, I just keep on feeling it doesn't fit in nicely into the POPI domain. I don't think it was, especially in the case of juristic persons, I don't think it was ever intended to form part of a data protection statute. So maybe we're just analyzing it too much. As Raki said, we are POPI nerds and we like doing this. And also, Raki, you focus in the beginning of your session on parties domiciled in South Africa, responsible parties domiciled in South Africa. But of course, POPI's reach is so wide, it can even catch a responsible party not domiciled in South Africa, but processing personal information in South Africa. And like Raki said, processing is anything. So you touch a trademark for somebody in South Africa and you make use of some sort of automated means in South Africa, and that is very widely defined, then our Protection of Personal Information Act will even catch an offshore responsible party or data controller. So certainly very interesting.
Yeah,
Andrea, or Raki?
Sorry. No, just looking to move on to the next question, if that's okay, unless Andrea, you had a last comment on that.
No, nothing from my side. I look forward to seeing how it plays out.
Yeah, definitely. I think we all are. But Era, just leaning on, you spoke about, juristic persons, and quite rightly so, that does apply to persons that are not domiciled in South Africa as well, and information in the public domain. But perhaps we can turn to another category of personal information like biometric information. I find this one to be quite interesting in the intersect between IP and POPIA. So for those that may not be familiar, I'll just give a quick example. Some of you may use, so you have a password on your phone when you want to unlock it, or some of you might use a face ID. So, where you see people just like randomly trying to slap the phone in their face so they can unlock their phone. So that's how sometimes it looks. But that is a technology using facial recognition technology, trying to decipher and identify the various markers on your face, which actually constitutes biometric information, but naturally it also uses, technology which can be protected by IP. So that's one category. There are other categories of biometric information like genetic information. So Ira, from your perspective, how does POPIA regulate, the processing of these biometric information?
Yes, Rocky. So as far as special personal information is concerned, we always say your special personal information, which includes your biometric information, health information, information relating to race and so on, information around alleged criminal proceedings and criminal offenses and so on. We always call this red flag information, because the minute you hit that type of data, you need to be extra careful. And generally, unless there's a clear-cut law that says you can process that stuff, or you've got data subject consent, then it is quite difficult to process that information. So back to biometrics. Now, biometrics is a especially difficult one, because biometrics or biometric information is not defined in POPI, but biometrics are defined to involve some sort of technique, and this is where Iraqi gets that technology from. It uses some sort of technique that uses physical, psychological, or behavioral characteristics to basically help you identify a person. So this, to my mind, could include things like lie detector tests, psychometric tests, and certainly facial images. And the GDPR now specifically says biometric data includes your facial images. Presumably, you have to do something to that facial image, but maybe the photo itself, maybe the fact that it was taken by a camera, that might already be a technique. So lots of questions surrounding when, in fact, would a photo be biometric information, if it would be biometric information at all, and I certainly think it would be. And then, yes, to complicate matters, Rocky, now we throw in the techniques and the IP surrounding the techniques. From a POPIA perspective, I would certainly say if you've got an app or something like that, build in consent to the use of that information. But I don't know what sort of pitfalls there are in terms of the IP laws there, Andre.
Yeah, I think that's a pretty good point. When I said we have to take a step back and differentiate between databases and data points, there's actually a layer that goes over that. And that would typically be, firstly, how you gather the information, and then how you actually interpret that information, both of which will definitely involve versions of intellectual property rights. So as an example, you mentioned facial recognition. The actual sort of mechanical tool that does that, call it a camera, but maybe it's a little bit more complicated than a camera. That tool and the underlying software, which actually maps the face and interprets whatever it needs to interpret, there are big intellectual property rights in that. That can typically be things like patents or copyright in the software, whatever the case is. So just gathering the data would have big intellectual property assets sitting behind it. And then one step further, once you have the data, actually interpreting the data as well would have different types of intellectual property rights in it. I'm talking about the algorithms that actually drive the analytics or whatever the case is. Now, obviously, you have a database to get some form of an answer at the back end. And you don't have people that sit and do it. You actually write a piece of code to do that for you. And there are massive intellectual property rights that reside in those sort of overarching technologies. So again, that drives the point that there are different elements in play here, and there are different intellectual property rights within that ecosystem that can play a role. Specifically on biometrics, I know we're talking about facial recognition and things here. The one that always interests me is genetic data, and that's because I've done quite a bit of work in the pharmaceutical industry, and there's a big push to use genetic information in sort of early stage clinical trials or even preclinical trials. So the theory goes that if you have enough genetic information and enough computing power, then you can cut down drug development times by a lot. So there are these numbers that always float around. All of them are wrong, but it costs $1.3 billion or $1.5 billion to go from molecule to market for a pharmaceutical. And the thinking is that if you can cut that cost down, those initial stages down by leveraging genetic data from people, then that is obviously a massive win for the pharmaceutical company. But then we come back to the actual owner of the intellectual property in the database and the data points. Do they deserve to get something for that use? And again, I'm not here to provide answers. I know where I sit morally on it. Legally, it's a little bit difficult to sort of articulate that. Back to you, Rocky.
Thanks, Andre. Yeah, definitely fascinating. So we'll have to wait and see where it all lands up, I guess, in the next few months. But perhaps moving on to see, let's talk a little bit about owning databases, what that might mean under POPIA, and then, especially like when you look at POPIA, it regulates the processing of personal information in order to send direct marketing messages. And with POPIA, we've now moved from an opt-out regime to an opt-in regime in respect of electronic communication. So, necessarily, if you're going to be doing any kind of direct marketing, you would be using a database. So perhaps, Ira, from your perspective, what does POPI say about, I guess, databases and direct marketing and everything else in between?
Thank you, Rocky. As you know, this is one of my favorite topics. So what I'm going to say now will only pertain to electronic direct marketing. So the minute we're doing electronic direct marketing, so we're using our SMS or MMS, or if you use fax numbers, targeted social media, if you use personal information behind that social media, then we trigger that horrendous Section 69. And like Rocky says, it is an opt-in electronic direct marketing requirement unless a person is your existing customer. So if you can argue that a person is your existing customer, for example, you received their contact details in the context of a sale and you've given them an opt-out to direct marketing, then you are going to have to get an opt-in from that person. Now, if that person opts in, we can only ask them once to opt in, and it must be in a prescribed manner and form, which makes it far more difficult than the rest of the world. But when that person now opts in, that we can use their personal information for direct marketing purposes, can we then say we own that personal information? I certainly don't think so. Rocky, I don't think I can own your telephone number. I don't think I can own your name. But this is where the question comes in, who owns that database? And I think from a POPI perspective, ownership is not the question. The question is, what are you allowed to do with that data? So are you allowed to market to that data? And what if I now sell the database to somebody else? Can that new person now market to that database? So incredibly interesting perspectives from a Section 69 perspective as to whether you can use that data and what if you sell that data. Andre, as far as the IP in a database is concerned, I know you looked at it just now already in the beginning of the session. Anything else you want to add here?
No, I think just that sort of golden thread that there certainly is ownership in a database. What you can do with it after you own it is an entirely different question. Obviously POPI will kick in and determine what you can do with it. But for our purposes, it's very important for us to, number one, understand that there are ownership rights in the database, and secondly, who the actual owner is of that database. So typically, it would be the person that consolidated that database or put it together. I won't go into details on, like, if you, for instance, if you have AI technology that actually consolidates that database for you, or crawlers that run all around the internet and gather everything and put it together in a database for you, who exactly owns it, it becomes a little bit messy. But for our purposes, it is extremely important to understand that chain of ownership, to understand who owns it, and then we hand over to you, and you guys can decide what they can do with it or not. But dropping that down one level again to someone like Nicole's first name or telephone number, those are viewed as information points. And you're quite right, at least under our law, there's nothing that states that's an intellectual property right. Where that does become a little bit interesting is if you look at things like personality rights. And again, I'm not going to drill too deep into it. A personality right isn't typically a clear-cut intellectual property right. It's more sort of intangible asset that you have. And the thinking is sort of, I've got the right to limit how my image is commercialized or used out there without me even being a celebrity or anything. Celebrities have that even more. And I think there's probably something there around the ownership of personal information, but I would almost hesitate to offer an opinion on that before it's been considered by people much, much smarter than I am.
And then, Andre, just to add to that as well, what is quite interesting and what we didn't focus on enough, I think, so far today, is that personal information in terms of POPI. So information in terms of POPI would only become personal information, which triggers the application of POPI if it relates to an identifiable person. So, for example, there's room to argue that if you have random numbers generated by computer code and they're not linked to an identifiable person, at least for a little period in time until you go and decode who that belongs to by phoning them and working out that it's Nicole's number or Raki's number, at least for a little period of time, we can argue that that stuff is not personal information. It is just algorithms, it's just data. So very important that we also realize that not every single data point, not every single item on a database would necessarily be personal information. It depends on what we have about that person. Do we have enough pieces of the puzzle to make the person behind that information identifiable?
I think that's where we've not had clarity so far, and I don't think there is actually a clean answer for that. If we work with these type of databases, you know, the client would typically tell you, no, there's no personal information in there. I don't know if that's true or not. So from our point of view, we deal with it as a single asset. But, you know, from your point of view, you're quite right. It's quite likely a mix between personal information and non-personal information. And there must be a tipping point somewhere in the middle where if we say, okay, now POPIA applies or now POPIA doesn't apply. And I think that's been a very difficult thing for us to identify when we work with databases as assets in transactions and things.
And, you know, typically people will also think that statistical and historical and research data would not fall under POPI. But if it is linked to identifiable persons, absolutely, then that would also be personal information, and POPI would apply to that. So I always say it's very key to work out, first of all, in terms of POPI, are you dealing with personal information? That's POPI 101. We always have to check whether the piece of data we are dealing with can be linked to an identifiable living human being or existing company.
Yeah, thanks, Andre. I can see you've already sparked a lot of interest in our listeners, and there are lots of questions streaming in, so we'll try and get to those in a short while. But perhaps we can move on to another topic that is quite interesting as it intersects between IP and data privacy. So I'm sure many of you would have heard of the Experian data breach that took place, recently. It affected, so Experian is a consumer and credit information agency, and their data breach actually involved a fraud. So there was a person that impersonated a director of a company for services, and in doing that, Experian then shared this information with this fraudster. And not only was data exposed in terms of, a data breach in terms of POPIA, but I would say there was also, sharing of information that affected IP rights in that instance. So Nicole, what do you think around, the theft of data under POPIA?
So we talked a lot about ownership of databases, but on the flip side of that, databases are a very valuable commodity to fraudsters. We've seen a number of high-value data breaches in the last couple of years, particularly under GDPR, where there have been targeted attacks on databases. If we look at the BA breach, the Marriott breach, Ticketmaster, I mean, there were multi-million-pound fines issued for the security and things placed around those databases. But ultimately, you had fraudsters that were able to penetrate the systems and exfiltrate that database and then sell it on the black market. And we see that it's a very valuable commodity out there with each piece of information set then being sold on the dark web for a priced amount. So certainly, I think what this leads us to, at the very least, is a thinking that POPI prescribes certain or places obligations on responsible parties to safeguard personal information under our 7th processing condition, to put in place reasonable technical and organizational safeguards to protect the confidentiality and integrity of our personal information. And where I think that can be useful is if we're starting to implement good and robust security mechanisms around our personal information. Likewise, we're going to be giving ourselves more support on protecting our intellectual property rights. So looking after certain databases, looking after certain types of technology, looking after it through the safety measures that we deploy under POPI. So I see there's actually, instead of them being juxtaposed against each other or in conflict with each other, we see a synergy where the one can actually benefit the other. Likewise, when we turn to the breaches, we often have two things happening simultaneously. And what we've seen a lot of outside of exfiltration of databases is your own employee conduct amounting to a data breach, where you have a issue with a current employee and they tend to take information and use it for a nefarious purpose. There was a big case in the UK in the last couple of years. It's the Morrison supermarket, where they had a employee that was involved in a employment process there. And in the course of being upset with his employer, he took 100,000 staff's payroll information and he downloaded it onto a flash drive and he uploaded it onto a public file share system. The difference there is that while we have a loss of some sort of database, and that may not be protected by IP rights, ultimately in the UK, Morrison's wasn't found to be vicariously liable when a class action suit was brought by the affected employees. But POPI is actually different, and it gives us a slight sting in the tail, because we have the section 99(1) of POPI, which actually gives us a vicarious liability or strict liability component, where irrespective of intent or negligence on the part of a responsible party, if there's harm that's caused by virtue of breaches of the Act, that responsible party could be liable at the end of the day. So if a similar situation is placed into a South African context, it's very likely that the employer in that context would have been found guilty for damages, including aggravated damages under POPI. And at that point, I think I'm going to hand over to Andre for his comments on this, because he sees this in terms of theft of IP databases quite often.
Yeah, thanks, Nicole. It's an interesting point. The sort of IP theft in a South African context has become a complete topic by itself. But specifically, as it relates to data breaches and more specifically to employees, we've seen that more and more often, where we have the normal IP recourse that you would have anyway, whether that's as an employer or as the IP owner, which is great. But those rights can be quite difficult to enforce and quite pricey to enforce as well. I think what we've found dealing with a few recent matters was that the POPI team and the IP team dovetail quite nicely from an enforcement point of view on a lot of these things. And we've been able to get quite positive outcomes for our clients by sort of, leveraging these two aspects of the law off each other. And I think that also prompted part of this conversation, was because we started working together so much more on the enforcement side. I know there's some other legislation in the pipeline as well that may be even more useful in future.
Yeah, absolutely. So many of you may know that, we've had the cybercrimes bill floating around for a long time. It was initially the cybercrimes and cybersecurity bill, but we now have just, they dropped the cybersecurity aspect of it, and we just have the cybercrimes bill. And in section 12 of the cybercrimes bill, once it's law, you might have another remedy there as well, And that is that, it will become a common, what it says is that the common law offense of theft must be interpreted so as not to exclude the theft of incorporeal property. And I think that's massive in this context as well. It will really give, responsible parties additional remedies in this respect when there is these thefts of IP and, personal information that takes place. How they all intersect is going to be very interesting, but I guess, we have more claims or remedies, which is always good. So I know last but not least, but it's one of the things I think we've touched on in between throughout the conversation this afternoon, is around, the commercialization and commoditization of personal information. So in, the corporate commercials side, we see in commercial transactions, especially when there's a sale of a business or some kind of acquisition that's taking place, one of the main assets that forms part of that acquisition is the databases. It's one of the most important parts of many companies. And, they'll have very nice clauses in those contracts dealing with, the people's rights and ownership of those databases. And we've touched on that in quite a bit of detail today as well. But it's really interesting because just because there's a contract that gives parties the right to use a database, under POPIA, you might not necessarily be allowed to market to that database. It's not such an easy sort of answer. You can't just say because you have the right in the contract that you'd be able to send these direct marketing communications now, because it might have been that the consents that you drafted were too narrow and they might not allow you to transfer those consents to another party. But I know, Ira, this is definitely something that's quite topical and relates to direct marketing quite neatly. What do you think?
Yes, absolutely. It's very important to see what that consent actually says, Rocky. If that consent allows for a transfer to another responsible party, for example, then you would be fine. But like I say, it really is fact specific. And when we talk about commercialization of data, I think it's, we always quote Mark Zuckerberg, who said data is the new oil, but we must also remember the late Steve Jobs, who said privacy is in people knowing what they're signing up for. Tell them in plain English exactly what they're signing up for and tell them repeatedly. So we are always so concerned about the consent aspect and what can we do in terms of consent, but we must always remember that we also have those notification duties in terms of POPI, where we do tell people, quite aside, even if we were going to rely on things like legitimate interests, we need to tell people what we are going to do with their personal information, who we're going to share that information with, and so on. So I think it's always very important that we've got a very nicely drafted privacy statement that we bring to people's attention whenever we can, so that they know exactly what we are doing with their data.
Thanks, Ira. I wonder if there's any last comments from the panel, or if you are all happy to move to questions. We do have quite a few.
I just have one comment around the commercialization of databases. Now, again, I'm not talking about the data points of the database itself. I think that circles back to one of the first comments I made, was if you identify it as an intellectual property asset, then any of the normal commercialization strategies apply. And just as an example, we recently did a transaction between two very big listed entities in South Africa, and the one didn't actually want to give up their database and the other party just wanted to use a part of it. So you would build a sort of normal licensing arrangement between the two, like you would for any other intellectual property asset, where the one guy gets to keep it and use it and the other guy can only use it to market to these specific clients and only for these services. But those type of arrangements, or at least in that case, became extremely complex, just from a sort of legal drafting point of view on who can market to which individual for what service. What I'm quite interested to understand is, how would that licensing arrangement potentially affect the underlying permissions? If you gave permission for party A to do A, B, and C with your data, can he then extract that one element and license it to someone else? Will it come down to those initial approvals? I don't know how that would work. Nicole, Ira, do either of you know?
Yes, that's very, very interesting. And if you look at the provisions of Section 69 that regulates that direct marketing, it's very specific that you must use a prescribed form when you get the opt-in. but you can use a form similar to that prescribed form, and you would have to read it with all your other consents. So, Andrea, I think potentially it is doable, but one would be very, very careful with how you draft those marketing opt-ins, that it's not only for one party, that it could be for a licensee as well. So you would have to be very careful.
And presumably that also means when you gather the data up front 5 years ago, that's when the contract should have made provision for it. To try and do that after the fact would presumably be pretty difficult.
It's very difficult, Andre. Going forward, I mean, you can cure quite a few elements with a privacy statement that you bring to people's attention. But for example, in terms of POPIA, you can market to existing customers, but an existing customer is seen as a person to whom you gave an opt-out when you collected the information. So we sit in this predicament where you might have collected that information 20 years ago. You didn't even know POPIA was coming, and you didn't give them opt-outs. Can we now argue that they're still customers for POPIA purposes, or must you go back and get a Form 4 consent from them? These are really, really difficult questions.
And then just an interesting point on that, there was a recent fine issued under GDPR. There was a software program that was randomly generating numbers for direct marketing purposes. And that marketer was actually fined because it was seen that those numbers that actually are randomly generated, if they link back to somebody's personal information. So you can try and do something different per se to try and get around direct marketing provisions, but it doesn't mean that you get there.
Yeah, very interesting and very complicated, actually. Anything else from the panel?
Rock, if I can just add something, I saw we had a question here. What if I have enough information about a person? And I think Janine mentioned the question here, well, she calls it deadly combinations. What if I know there's a single female living somewhere with a child, and that per se might not be personal information, but it could lead to a lot of harm if somebody abducts the child or something like that. I'm paraphrasing. I just want to make it clear that personal information is not necessarily the name of a person. If I have enough information that relates to an identifiable person to go and find this person and her child, for example, that could be personal information regardless of having a name of that person. So I just wanted to clarify that. And as far as legitimate interests are concerned, I also saw a question coming up there, I think for my attention, on legitimate interests. Can we process information that is subject to IP because it's in our legitimate interest to do so? I think it's very important to always note that my legitimate interests are not absolute. It must always be weighed up against the other party's rights as well. So to my mind, I can't, for example, go and use somebody else's trademark if it's a licensed trademark. And Andre, I can't remember the laws of passing off and any of that stuff anymore. But if somebody else has got a lawful right to use that trademark, I can't just say it's in my legitimate interest to use it. We would have to weigh the rights against each other. And my gut feeling here would be that I wouldn't be able to use that trademark. And that's it from me, Rocky. So you can you can start with the questions.
Thanks, Ira. So we'll take the first question. So it says, in terms of processing special personal information in respect of employees like race, gender, disability status, and for purposes of BE reporting, does it require special authorization, or does that not apply due to BE being governed by South African law? So I think, Ira, the question is, or maybe I can sort of start and you can add in, because you're processing special personal information, you would need a special authorization. So, but one of the special authorizations may be where you are required to comply with the law. So that means you wouldn't need to get express consent for processing that special personal information for reporting on BE. I hope that answers the question. Okay, we'll pick another one. Ira, I think this might be for you. The definition of personal information includes a symbol, but it omits reference to intellectual property rights. There may be an overlap, but can we exclude most IP rights?
I think it's two different questions, or two different scenarios altogether. I think something like a symbol could be personal information, and it could then also be a trademark in terms of IP laws. So I think it's two completely separate issues. I don't think the definition of personal information is trying at all to touch on other rights here, like copyright or law of trademarks or anything like that.
Yeah, I think I agree with that. I don't think there's an intention under POPI, and I'm not a POPI expert or a nerd, POPI nerd. I don't think there should be an intention to try and regulate other areas of law under this act. But I think what is important is, again, this intersection. If we look at personal information, take someone's name, for instance, someone's name can legitimately be a trademark as well. And that trademark can then actually be on-sold to someone else so that you can't use it anymore within the context of that trademark. So it becomes a little bit blurry between those lines. And then you just need to draw it back to what exactly, try to identify that underlying intellectual property asset to understand what it is and what you can do with it.
Yeah, absolutely. Thank you, Andre. The next question was, so they're a software trainer. What differentiates them from other trainers is the way they present their content and teaching style. They use various methodologies that they've come up with themselves to convey content to an audience. They also create their own content and use with their own teaching style, and that might be their own IP. So will POPI be able to protect my teaching style and the content I create, or is that tricky to govern? And I think, Andre, this is exactly what you were just saying, but maybe if you just want to clarify in this context.
No, absolutely. I don't think POPI is intended, and again, I can be corrected by the other people on the call, to apply in that scenario, but that certainly is your intellectual property. I won't go into a lot of detail on that, but of course you can get rights in your content that you use to teach other people and in the methodologies that you do that. Depending on what exactly it is that you do, if you write a specific app, for instance, that teaches kids how to count, of course you get intellectual property rights in that app, in the software in the app. It becomes quite a wide question. So I think that one I'm going to leave there. And if you've got more specific information, I think you need to contact us and we can just chat through the do's and don'ts.
Great, thank you. Nicole, I think this one's for you. They say, how is personal information to be safe? For example, hard copies in locked fireproof filing cabinets, soft copies in cloud password protected.
So how long is a piece of string? POPI doesn't tell us how we need to look after our information. It tells us we must look after our information. It tells us we must be reasonable in what security measures we deploy. I think that there are certainly some gold standards that have been seen as acceptable, but at the very least, we need to have, firstly, organizational measures that look after things. So that could mean things like access controls to your building, printed policies, those sorts of softer things. The next thing is, what do we do with our technological measures? Are we using some basics like password protections and encryptions? But sometimes it's a case of security keeps the good guys out, and anybody can hack into anything if they really wanted to. But what you have to be able to demonstrate is based on the sensitivity of the information and the volumes of information and the risk of harm that comes from holding that information, that the measures you've deployed were reasonable in those circumstances. So we'll see when we get some guidance down the line what that will mean.
Thanks, Nicole. The next question was, maybe Ira, for you, can a person visiting a mall be regarded as an existing customer? No more information than that.
Well, visiting a mall, first and foremost, would not necessarily trigger the application of POPI. Some sort of processing of personal information must happen. So it could be them capturing my images on CCTV cameras, or them asking me to fill in some form, or I may shop somewhere and then give them contact details. So for POPI to apply, there must always be the processing of personal information. Now, let's say I visit the mall and somehow they get some of my information, which I give to them. Let's say I use a free Wi-Fi service there, or I sign up for some competition. There it would be interesting to note who is now the responsible party. Because we could argue that I'm an existing customer of the responsible party, but if there is the responsible party now the shopping center, or is it a certain shop where I stop to buy lipstick? So that would be the second thing that you would have to work out. And then, did they give me an opt-out? Did they say to me they're going to use my information for direct marketing purposes when they collected my details? And there must be a context of a sale, and that we can play with. Did me visiting the mall, does that equate to in the context of a sale? Sometimes it does, sometimes it doesn't. There's some guidance overseas that says if I go and look at somebody's website and I show an interest in products, that by itself could already trigger those customer provisions. So if you want more detailed advice, please feel free to contact me, but that is really about the best I can summarize, about 10 pages that you need to consider going into that.
Yeah, thanks, Ira. I think this last question, and I know I'm skipping around, but I think it's very important to maybe just clarify this point. So somebody asked, if you have a conflicting situation regarding IP law and POPI law, which will prevail? So, I mean, POPI actually says that the laws that give data subjects the strongest rights will generally apply, but there should never really be an instance where the laws conflict because they deal with different aspects of law. So, IP law deals with protecting your rights to ownership, whereas POPI deals with, consumers' rights, or just generally data subjects' rights to privacy. So I don't know if you have a more specific question, but in general, I don't really see if there would ever be a conflict. I don't know if Ira, Andre, and Nicole, you want to just add to this point?
No, I agree with you there. They serve different purposes. We should read them together. And for example, if POPI gives me a right, like to process information where it's necessary to pursue my legitimate interests, then I can't see that in isolation. I must weigh it up against your rights that you may have in terms of intellectual property. I don't see that as a conflict at all. It might be a balancing exercise, if anything.
Okay, I think we have time for one last question. So I'm going to take the anonymous one, and then to the extent that we may be able to, we'll try and get back to you, but we'll do our best. So the last one was, if staff members are using social media, so their private and company accounts, what needs to be included in a social media policy to make sure that it's compliant from a staff perspective? Does social media fall under direct marketing?
Well, I can jump in here. Social media, if you use personal information in certain instances, would definitely be direct marketing. If you use a mirror audience or lookalike audience who are looking for people between the ages of 35 to 40 who may be interested in traveling, then often it wouldn't be seen as direct marketing, just as targeted advertising or targeted marketing. But the minute you're processing personal information in the background, for example, uploading a customer list to that social media platform, that is where the POPI implications kicks in. So absolutely, social media policies, bring your own device policies, incredibly important to have. What should be in there? Restrictions as to, and rules as to what you can do on social media, especially if your company is identifiable from information that you put out on social media.
Yeah. Thanks, Ira. Unfortunately, everyone, that's all we have time for this afternoon in terms of questions. We'll do our best to try and get back to you over email if you've left your name and provided your email address. Many of you have been asking if the webinar will be available. So it is being housed and being live streamed on YouTube, and it will stay on our account there as well. You'll also receive a note from us tomorrow with a link to today's webinar if you did want to access it later. Thank you so much to my colleagues for joining me this afternoon. Definitely interesting, stimulated the POPI nerd in me, Andre, the IP nerd in you, I'm sure. But have a good rest of your afternoon and good luck with your compliance. We look forward to hearing from you.
Bye, everyone.
Bye, everyone.
Everyone, bye.